Don't sit there acting confused. You expect me to believe this is your vehicle?
It is registered to me. You verified that.
Registered doesn't mean earned. Cars like this don't just land in the hands of someone like you without something shady behind it.
Am I being charged with a crime?
No.
At 9:47 on a quiet Sunday morning along Meridian Boulevard in Crestwood, a matte black Lamborghini Urus rolled through a green light at the intersection of Walnut and 5th. The driver signaled, changed lanes, and continued at exactly the posted speed limit. 6 car lengths behind her, Officer Brent Hargrove, 42, a 16-year veteran of the Crestwood Police Department, sat behind the wheel of his patrol cruiser and watched. His dash cam was running, his body camera was active. Both would later confirm what happened next. Hargrove followed the Lamborghini for 6 full blocks. He didn't activate his lights. He didn't run the plates. He just followed, watching, waiting for something he could use. At the 7th block, he hit the sirens. He called it in as a suspicious vehicle, possible stolen, and noted a failure to signal during a lane change. The dash cam would later show the signal blinking clearly, 3 full seconds before the merge. The driver, who pulled over without hesitation, placed both hands on the steering wheel and waited calmly for the officer to approach, was Federal Judge Genevieve Okafor Laurent. She was 53 years old, a sitting judge on the United States Court of Appeals for the 4th Circuit, and one of the most respected jurists in the federal system. She was on her way home from visiting her elderly mother across town. She wore a linen blouse, sunglasses pushed up on her head, and no identification that would mark her as anything other than what Hargrove had already decided she was: a black woman driving a car he didn't believe she could own. Officer Brent Hargrove had been with the Crestwood Police Department since he was 26 years old. In that time, he had accumulated 31 civilian complaints, the overwhelming majority filed by Black and Latino residents. The complaints described a pattern that never changed: pretextual stops, aggressive questioning, searches conducted without consent or probable cause, property seized and never returned. Hargrove had earned a nickname in the neighborhoods he patrolled most heavily. Residents called him the Collector. Not because he collected evidence, but because he collected belongings. Cash pulled from wallets during traffic stops, jewelry removed during pat-downs and logged as potential proceeds of criminal activity, electronics confiscated under civil asset forfeiture statutes that allowed police to take property without ever filing charges. Over the past 5 years alone, Hargrove had seized more than $340,000 in cash and personal property from citizens. Almost none of those seizures led to arrests. Almost none of that property was ever returned. 2 prior cases involving allegations of planted evidence had been quietly settled by the city before reaching trial. Internal Affairs had reviewed his file multiple times and closed every investigation without action. His supervisors described him in evaluations as assertive and proactive. The police union representative, a man Hargrove met for drinks twice a month, had personally intervened to block 3 separate disciplinary recommendations. Younger officers who questioned his methods were told to mind their own calls. Those who pushed further were transferred. Hargrove operated with the confidence of a man who had never once been held accountable. And on this Sunday morning, with his lights flashing behind a Lamborghini Urus on Meridian Boulevard, he had no reason to believe that was about to change. Judge Genevieve Okafor Laurent was not the kind of person who announced herself. She never had been. Her father, Chukwemeka Okafor, came to the United States from Lagos in 1974 with $200 and a work visa. He drove a taxi in Washington, D.C. for 31 years, 6 days a week, often pulling double shifts so his children wouldn't carry the debt he did. Her mother, Ruth Ann Laurent, grew up in Orangeburg, South Carolina, the granddaughter of sharecroppers. She cleaned office buildings at night and took community college classes during the day until her body gave out before her ambition did. Genevieve was the youngest of 3. She earned a full scholarship to Howard University, graduated summa cum laude, and was accepted to Yale Law School, where she was one of 9 black women in her class. She clerked for a Supreme Court justice. She spent a decade as a federal prosecutor in the Civil Rights Division of the Department of Justice, trying cases involving police brutality, unlawful search and seizure, and systemic discrimination in law enforcement agencies across the Southeast. 9 years ago, she was appointed to the United States Court of Appeals for the Fourth Circuit. She had since authored or joined rulings in more than a dozen landmark cases involving police misconduct, qualified immunity, and constitutional violations under the Fourth and 14th Amendments. Legal scholars described her opinions as surgically precise. Defense attorneys feared her bench. Civil rights lawyers cited her rulings like scripture. None of that was visible on Meridian Boulevard that morning. What Hargrove saw when he looked through that window was a black woman in a linen blouse sitting behind the wheel of a car he had already decided wasn't hers. And that was all he needed. Hargrove approached the driver's side with his right hand resting on his belt. His body camera captured the angle from his chest. The dash cam recorded the wider frame from the cruiser. Both were rolling. Both would preserve every word of what came next. He didn't greet her, didn't introduce himself. His first words were a demand. "Whose car is this?" Judge Okafor Laurent looked up at him, hands still on the wheel. "It's mine. You have proof of that?" She reached toward the center console slowly, movements deliberate and visible. "My license and registration are right here." Hargrove took the documents and studied them far longer than necessary, flipping the registration back and forth, holding the license up as though comparing the photo to a face he had already decided didn't match the vehicle. He walked back to his cruiser. He ran the plates. The vehicle came back registered to Genevieve Okafor Laurent. The license was valid. No warrants, no flags, nothing. He sat in the cruiser for nearly 4 minutes. Then he got out and walked back to her window. The body camera captured what came next without interruption. "Step out of the vehicle." "For what reason?" Okafor Laurent's voice was steady. "I need you to step out." "I've provided my documents. Everything is in order. Why am I being asked to exit my car?" Hargrove leaned closer. "I'm detecting the odor of marijuana coming from inside this vehicle." There was no marijuana in the car. There had never been marijuana in the car. Forensic analysis would later confirm that no trace of any controlled substance existed anywhere in or on the vehicle. But in that moment, on the side of Meridian Boulevard, with no witnesses yet watching and both cameras running, Hargrove had just manufactured the one claim he believed would give him the authority to go further. And he intended to. "Step out, now!" Judge Okafor Laurent opened the door slowly. She placed one foot on the pavement, then the other. She stood upright, hands visible at her sides, and spoke clearly enough for every microphone in range to capture it. "I am complying with your order under protest. I do not consent to any search of my person or my vehicle." Hargrove didn't acknowledge a single word. He took her by the arm and moved her to the rear quarter panel of the Lamborghini, positioning her against the car with both palms flat on the matte black paint. He patted her down with hands that moved too slowly and pressed too hard, running his palms along her sides, her waist, her pockets. She stood motionless, jaw tight, eyes fixed on the street ahead. A second patrol unit had already arrived. Officer Nolan Fitch, 29, 5 years on the force, stepped out and approached. Hargrove jerked his head toward the open driver's door. "Toss it." Fitch hesitated. His eyes moved from the woman standing composed against a $250,000 vehicle to the registration documents sitting clean on the hood. He opened his mouth like he was going to ask something, then didn't. He reached into the car. They emptied her purse across the hood. Wallet, reading glasses, a leather planner, a tube of hand cream, receipts. They opened the glove compartment and pulled out the owner's manual and insurance papers. They lifted the floor mats. They searched the center console, the door pockets, the trunk. In the back seat, they found a small zippered bag containing her mother's prescription medications. Hargrove unzipped it, spread the bottles across the leather seat, read the labels one by one, then left them scattered where they fell. They found nothing illegal, because there was nothing illegal to find. Across the street, in a second-floor window of a brick colonial, a woman named Celeste Gerard had been watching since the lights first flashed. Her phone was recording. She didn't say a word. She didn't need to. Hargrove stood in the middle of the road, feet apart, hands on his hips, staring at the open doors of a vehicle that had given him nothing. No drugs, no weapons, no contraband. No justification for a single thing he had done in the last 20 minutes. The body camera on his chest kept recording. He turned back toward Judge Okafor Laurent, still standing where he had placed her, palms flat against the side of the car, and what came out of his mouth next would be replayed in federal court, in news broadcasts, in training seminars, and in living rooms across the country. Let me ask you something. A woman like you, driving something like this, how does that happen? She said nothing. He stepped closer. Did your boyfriend buy this for you? Some rapper? Some dealer? Because I've been doing this a long time, and cars like this don't end up with people like you unless something dirty is going on. His voice was casual, almost conversational, as if he were stating something so obvious it barely needed saying. This car costs more than you'd make in 10 years, so I'm going to ask you again, where did the money come from? Okafor Laurent turned her head slightly. Am I free to leave? Hargrove's expression hardened. You'll leave when I decide you can leave, not before. Angle. A second neighbor, 2 houses down. Angle. A second neighbor, 2 houses down, had stepped onto his porch and started filming. A passing driver slowed at the intersection, window down, phone raised. 3 cameras were now recording from 3 directions, and the body camera on Hargrove's chest made 4. None of them would miss a word of what had already been said, and Hargrove, standing in the middle of Meridian Boulevard, with his chest out and his badge catching the morning sun, had no idea that every syllable was building the federal case that would end him. There was a moment, captured clearly on the body camera, where Judge Okafor Laurent's eyes moved from Hargrove's face to the badge on his chest and then back again. It lasted less than 2 seconds, but lawyers who reviewed the footage later would describe it as the moment she made her decision. She could have ended it right there. 1 sentence. I'm a federal judge on the 4th Circuit Court of Appeals. The stop would have collapsed on itself. Hargrove would have stammered. Fitch would have frozen. Apologies would have tumbled out, fast and hollow and desperate. She knew that. She also knew exactly what that would mean. It would mean that the Constitution applied differently depending on who you were. That rights were not rights at all, but privileges extended to people with titles and revoked from everyone else. That a black woman driving a Lamborghini deserved to be searched and humiliated, unless she could prove she was important enough to be left alone. So she said nothing about who she was. Instead, she asked for his badge number. Hargrove stared at her. What? Your badge number. I'd like it, please. He recited it with reluctance, each digit clipped and hard. She repeated it back to confirm. Then she asked him to spell his last name. He sneered. Hargrove. Slow enough for you? She didn't react. She filed it the way she filed everything, with precision, without emotion, with the patience of a woman who had spent 9 years on the federal bench, weighing testimony, dissecting evidence, and holding powerful men accountable when they believed they were untouchable. She had judged cases exactly like this one. She had read transcripts full of the same language, the same pretexts, the same arrogance dressed in a uniform. Now she was standing inside one, palms flat against her own car, living every word she had ever read in a case file. Hargrove keyed his radio. I need a K-9 unit at my location, Meridian Boulevard, south of 5th. Judge Okafor Laurent looked at him but said nothing. The temperature that morning was already 87 degrees and climbing. She was standing on asphalt in direct sunlight with no shade and no water. In the backseat of the Lamborghini, her mother's prescription medications sat in the zippered bag Hargrove had torn open, bottles scattered across dark leather that was absorbing every degree of heat the sun could give it. 2 of those prescriptions were temperature sensitive. The labels said so clearly. Hargrove had read those labels. He didn't care. The K-9 unit arrived 28 minutes later. Officer Dean Sutcliffe, 36, stepped out with a Belgian Malinois on a short lead. The dog circled the vehicle once, then again. It showed no alert behavior. No sit, no paw, no change in breathing or posture. Sutcliffe looked at Hargrove. "I'm not getting anything." Hargrove shook his head. He paused near the rear quarter. "That's a partial alert. Go again." Sutcliffe glanced at Fitch. Fitch looked at the ground. Neither of them believed what Hargrove had just said, and the body camera caught the look between them clearly. Sutcliffe walked the dog around a third time. Nothing. Hargrove ordered the vehicle searched again. Fitch opened the rear hatch and moved things that had already been moved. Sutcliffe stood to the side, leash in hand, silent. Fitch spoke quietly, barely audible on the body camera audio, but recovered during forensic enhancement. "Maybe we should wrap this up." Hargrove didn't turn around. "Shut up and finish." By the time it was over, 57 minutes had passed since the initial stop. 57 minutes for a lane change that was executed legally. 57 minutes that produced no citation, no charge, no arrest, and no apology. Hargrove handed back her documents without a word. Judge Okafor-Laurent gathered the medication bottles from the back seat, now warm to the touch. She noticed the scuff on the driver's seat leather where Fitch had leaned his tool belt. She sat down, closed the door, and pulled away from the curb at exactly the speed limit. She did not look back. Hargrove watched the Lamborghini disappear down Meridian Boulevard and returned to his cruiser. He logged the stop as a routine traffic contact with no further action. He had no idea that the woman he had just spent an hour degrading would by morning have the full weight of the federal government bearing down on him with a force his badge had never prepared him for. At 7:15 Monday morning, Judge Geneviève Okafor-Laurent sat at her desk in her home office with a legal pad, a pen, and a phone. She did not call the Crestwood Police Department. She did not file a civilian complaint. She did not leave a message with Internal Affairs. She called the United States Department of Justice Civil Rights Division. She identified herself by name and title. She provided her case number from the Fourth Circuit, her judicial appointment reference, and a detailed oral account of the stop, timed to the minute, citing the specific constitutional violations by amendment and clause. She then called the FBI field office and made the same report. Then the Office of Inspector General. Each call was precise, measured, and without emotion. She spoke the way she wrote opinions. Facts first, law second, conclusions last. By 8:30 a.m., she had submitted a written account, 7 pages, single-spaced, with timestamps drawn from her own memory and cross-referenced against the time she had noted on the dashboard clock during the stop. She requested preservation of all footage, Hargrove's dash cam, his body camera, Fitch's body camera, and the K-9 unit's records. She requested Hargrove's personnel file, his stop history, and his civil asset forfeiture records. Then she made one more call. Not to an agency, but to a civil rights litigation firm with a national reputation for police misconduct cases. She told them she was not calling for herself. She was calling because she wanted to know how many other people Brent Hargrove had done this to. People who didn't have a law degree. People who didn't have a title. People who didn't have the ability to make the calls she had just made. By the time Judge Okafor-Laurent closed her legal pad, the machinery of federal accountability was already turning, and Officer Brent Hargrove was on his way to work with no idea that his name was now in 3 federal databases. The footage arrived at the DOJ Civil Rights Division by secure transfer on Tuesday. Investigators reviewed every second from 4 separate sources. The dashcam came first. It showed the Lamborghini Urus approaching the intersection of Walnut and 5th, signaling a lane change 3 full seconds before merging and completing the maneuver cleanly within the posted speed limit. The failure to signal that Hargrove had used as his pretext for the stop had never occurred. The body camera footage was worse. It captured Hargrove's tone from the first word, the immediate demand to know whose car it was, the prolonged examination of documents that were in perfect order. Every one of them. Women like you don't. Every one of them. Women like you don't come by cars like this. Did your boyfriend buy it for you? This car costs more than you'd make in 10 years. Audio forensic enhancement recovered something the body camera microphone had barely caught in real time. Early in the stop, before Fitch had arrived, Hargrove had leaned toward his radio and whispered, "Bet you anything this thing's stolen or bought with dirty money. Look at her." The K-9 unit's records collapsed the marijuana claim entirely. Officer Sutcliffe, under questioning, admitted the dog had shown no genuine alert behavior at any point during the search. When asked about the partial alert Hargrove had claimed, Sutcliffe paused for a long time before answering. "There was no alert. I told him that. He said to go again." Investigators then pulled Hargrove's stop records. In the past 18 months, he had conducted 214 traffic stops. 178 of them, over 83%, involved Black or Latino drivers. Civil asset forfeiture filings showed he had seized more than $340,000 in cash and personal property during that same period. Charges were filed in fewer than 6% of those seizures. The rest of the property simply disappeared into the system, and the people it belonged to never saw it again. The investigators looked at the numbers, looked at the footage, and understood they were no longer investigating a single traffic stop. They were looking at a career. They arrived at 9 a.m. on a Wednesday without warning. 2 FBI special agents and 3 DOJ Civil Rights Division investigators walked through the front entrance of the Crestwood Police Department, carrying federal subpoenas and a preservation order for all digital records. They did not ask for a meeting. They served the documents at the front desk and requested immediate access to the Chief of Police. Chief Raymond Beckett, 58, came out of his office expecting a courtesy visit. His expression changed within 30 seconds. The subpoenas demanded Hargrove's complete personnel file, all 31 complaint records, every internal affairs investigation and its disposition, body camera server access logs going back 3 years, and all internal communications referencing Hargrove's stop activity, forfeiture records, or civilian complaints. Beckett's first instinct was to push back. He began asking about jurisdiction, about process, about whether the department's legal counsel should be present. The lead FBI agent let him finish, then told him the victim of the stop was a sitting judge on the United States Court of Appeals for the Fourth Circuit. The color left Beckett's face, but the agent continued before the silence could settle. "Her title is not why we're here. We're here because the evidence shows a pattern in practice of civil rights violations by an officer your department has protected for 16 years. That's a federal matter, regardless of who he pulled over last Sunday." Hargrove was on patrol when the call came through ordering him back to the station. He was met in the parking lot by a captain who told him to hand over his badge, his firearm, and his cruiser keys. He was escorted inside, placed in an administrative office, and informed he was suspended pending a federal investigation. His face went tight. He asked what this was about. Nobody answered. Fitch was pulled from duty the same morning and placed on administrative leave. The union representative, Victor Spano, arrived within the hour, demanding to know what was happening. An FBI agent took him aside and said one sentence that ended the conversation. "Obstruction of a federal civil rights investigation is a felony, Mr. Spano. I suggest you cooperate fully and advise your client to do the same." Spano said nothing further. For the first time in 16 years, the machinery that had shielded Brent Hargrove went completely silent. 3 weeks later, the United States Attorney's Office for the District filed a federal indictment against Officer Brent Hargrove. The charges were severe: deprivation of rights under color of law, 18 U.S.C. Section 242, conspiracy to commit civil rights violations, filing false police reports, illegal search and seizure in violation of the Fourth Amendment. The indictment ran 34 pages. It did not focus solely on the stop of Judge Genevieve Okafor-Laurent. It detailed a pattern spanning years. 47 identified victims, predominantly Black and Latino, subjected to unlawful stops, fabricated pretexts, warrantless searches, and civil asset forfeitures carried out without probable cause. It described a system in which complaints were filed and buried. Supervisors looked the other way, and one officer operated with impunity because no one above him had the will to stop him. Officer Nolan Fitch was offered cooperation terms within days of the indictment. He accepted. In his testimony to federal investigators, Fitch described what Hargrove was like between stops, the language he used in the cruiser when the body cameras were off, the casual way he selected targets based on race and vehicle type, the comments about certain neighborhoods and certain people that had become so routine, Fitch stopped registering them as unusual. He described an unwritten culture within the department where aggressive stop numbers were rewarded, where complaints from minority residents were treated as the cost of doing business, and where officers who raised concerns were quietly reassigned or frozen out of advancement. Fitch's testimony led investigators to two supervisors, Sergeant Dale Womack and Lieutenant Ira Fontaine, both of whom were named in the indictment as unindicted co-conspirators. Internal emails showed Womack had received at least 9 forwarded complaints about Hargrove over 4 years and had closed every one without action. Fontaine had signed off on Hargrove's forfeiture paperwork dozens of times, without once questioning the absence of corresponding charges. Neither man had been careless. They had been deliberate, and the federal government intended to prove it. The trial began on a Tuesday in a federal courtroom 40 miles from Crestwood. Hargrove's defense attorney opened with a simple argument. His client was a veteran officer who followed his training, trusted his instincts, and made judgment calls the way officers did every day. He called it experience. He asked the jury to consider the pressures of the job. The prosecution responded by pressing play. The body camera footage from the Lamborghini stop ran first. The jury watched from Hargrove's own perspective as he fabricated a marijuana claim, emptied a purse across the hood, scattered prescription medication across a back seat, and told a woman standing against her own car that people like her didn't come by vehicles like this. Then prosecutors played footage from 6 other stops, different days, different drivers. The language was nearly identical. The tactics were the same. Each stop involved a Black or Latino driver. Each produced no charges. 12 of Hargrove's other victims took the stand. A retired canine training supervisor testified that no alert behavior had occurred during the Lamborghini search, and that the partial alert Hargrove claimed did not exist in any recognized training program. A use of force expert testified that every element of the search violated the Fourth Amendment. Judge Okafor Laurent took the stand last. She was introduced by name alone. To have a stranger's hands press her. To have a stranger's hands press her against her own vehicle. What it felt like to watch her mother's medication scattered across hot leather by a man who never once considered she might be telling the truth. She described the moment Hargrove told her the car cost more than she'd make in 10 years, and she paused. Not for effect, because the memory required it. The jury deliberated for less than a day, guilty on every count. The sentencing hearing was held 3 weeks later. Hargrove stood in a dark suit, no badge, no firearm. The presiding judge, the Honorable Catherine Shao, addressed him directly. Officer Hargrove, you did not merely break the law, you weaponized it. You used the authority entrusted to you to target, humiliate, and rob citizens of their constitutional rights based on the color of their skin. You did this repeatedly, systematically, and without remorse. She sentenced him to 7 years in federal prison, among the harshest sentences for a civil rights violation by a law enforcement officer in the circuit's recent history. He was remanded immediately. Fitch received a suspended sentence for cooperation, but was permanently barred from law enforcement. His silence on Meridian Boulevard had cost him everything his testimony couldn't buy back. The Crestwood Police Department entered a federal consent decree, independent civilian oversight, mandatory demographic data on all stops and forfeitures, published quarterly, comprehensive retraining with annual testing, complete overhaul of internal affairs, including independent review of all racial bias complaints. Sergeant Womack and Lieutenant Fontaine were forced to resign. Chief Beckett announced his retirement 2 days later without public comment. The civil lawsuit was filed on behalf of Judge Okafor Laurent and 38 other identified victims. The city's attorneys reviewed the footage, the stop data, the forfeiture records, the emails, and the federal conviction. Settlement negotiations lasted less than a month. The final amount was $6.4 million, divided among victims according to severity and documentation. The money would matter, but what mattered more was the record. It could not be sealed, it could not be buried, and it could not be undone. Judge Genevieve Okafor Laurent returned to the bench without ceremony. She did not give interviews. She did not appear on panels about her experience. She let the record speak because the record was comprehensive and the record was permanent. But 6 months after the trial, she accepted an invitation to deliver the keynote address at a national legal conference on constitutional policing. She stood at the podium in the same composure she had carried on Meridian Boulevard and said what she had carried quietly since that Sunday morning. I did not tell that officer who I was, because who I am should not determine whether my rights are respected. The Constitution does not have a VIP lane. The room was silent for a long moment before the applause began. She used a portion of her civil settlement to fund a legal clinic specializing in representation for victims of discriminatory traffic stops, people who had been searched, seized from, humiliated, and sent on their way without charges, without apology, and without anyone to call on Monday morning. The clinic opened in a small office 12 minutes from Meridian Boulevard. Hargrove served his sentence in a federal facility where his former profession made every day harder than the last. He never issued a public apology. He never acknowledged wrongdoing. He maintained until the end that he had been doing his job. After the settlement. Traffic stop racial. After the settlement. Traffic stop racial disparities across the department had dropped by 61%. Complaints of discriminatory enforcement had fallen by more than half. Officers now recorded justification for every stop in writing, and every recording was subject to independent review. In the Oversight Board's office, mounted on the wall behind the conference table, hung a single framed image. It was a still captured from Hargrove's own body camera. It showed Judge Okafor Laurent standing beside her matte black Lamborghini Urus, palms flat against the paint, chin level, eyes forward. Beneath it, a single line in plain black type. The law applies to everyone, including those who enforce it. If you think this situation was bad, wait until you see what happens in the case on the right-hand side.
I am a federal judge. You can confirm that
Save it.
immediately.
Credentials don't put you above investigation.
I am asking you to verify before escalating this.
You think because you've got a title and a big house in this neighborhood that nobody's gonna...
At 5:47 a.m. on Saturday, March 1st, 2026, 12 armed Homeland Security investigations agents in full tactical gear executed a no-knock raid on a quiet residential home in Silver Spring, Maryland. A flashbang grenade shattered the living room window before the front door had even been touched. Then came the battering ram. The door splintered inward on the first hit. Agents flooded the hallway shouting commands, boots shaking the floor hard enough to knock framed photos off the walls. Barbara Okuosa Adeyemi was pulled from her bed in pajamas and thrown face first onto the hallway floor. Her wrists were zip-tied behind her back before she could finish a sentence. Down the hall, her 16-year-old daughter Rosaline was forced to the ground at gunpoint in her own bedroom. Bodycam footage would later show the girl's face, frozen in terror, a rifle barrel inches from her head. In the next room, 11-year-old Namdi stood paralyzed against his bookshelf, tears streaming down his face, a dark stain spreading down his pajama pants. Barbara's voice cut through the chaos, steady despite the pressure on her spine. I'm a federal judge. I'm a sitting United States federal judge. The agent kneeling on her back didn't flinch. Sure you are. Senior Agent Craig Loomis stood in the doorway of the bedroom, arms crossed, watching the scene unfold like a man observing routine work. He said nothing. He didn't need to. He had authorized every second of this. Craig Loomis was 46 years old, with 18 years in federal law enforcement and a career built almost entirely on post-9/11 fear. He had made his name running counterintelligence operations that targeted immigrant communities and black professionals with tenuous or outright fabricated links to foreign governments. 7 of his previous operations had collapsed before reaching trial due to lack of evidence. Not one of those failures resulted in discipline. 2 former colleagues had filed internal complaints alleging Loomis manufactured evidence and pressured informants into giving false statements. Both complaints landed on the desk of Supervisory Special Agent Donna Kessler, his section chief. Both were dismissed. Kessler had co-signed nearly every major warrant Loomis had pursued over the past 6 years. Among his peers, Loomis was known for what supervisors politely called big swings, high-profile raids designed to generate press attention and justify budget lines rather than produce convictions. He had been chasing a promotion to Assistant Special Agent in Charge for 2 years. He needed a headline case. And when Barbara Okuwosa Adeyemi's name surfaced during a routine intelligence sweep, Loomis decided she was it. Judge Barbara Okuwosa Adeyemi was born in Baltimore to Nigerian immigrant parents who had come to the United States with nothing but education and discipline. Her father taught biology at a community college. Her mother worked as a hospital administrator. Barbara earned her undergraduate degree from Spelman College, then her law degree from Harvard, where she graduated in the top 5% of her class. She clerked for a federal appellate judge on the Fourth Circuit, then spent 8 years as a prosecutor at the Department of Justice, specializing in national security cases, the very field Craig Loomis now worked in. 4 years ago, she was appointed to the federal bench for the U.S. District Court for the District of Columbia. Senate confirmed. Respected across the legal profession for her fairness, her sharp intellect, and her willingness to check government overreach in surveillance and civil liberties cases. She was one of only a handful of black women serving as federal district judges in the entire country. Her husband, Dr. Chukwuemeka Okuwosa Adeyemi, a cardiologist, had passed away 2 years earlier from pancreatic cancer. Since then, Barbara had been raising Rosaline and Nnamdi alone, balancing a demanding caseload with school pickups, Sunday church, and the quiet grief of a household that still had his reading glasses on the nightstand. She was deeply private, deeply principled, and deeply rooted in her community. She was also, in every measurable way, exactly the kind of person the system was supposed to protect. Instead, the system sent Craig Loomis. 3 months before the raid, Loomis flagged Barbara's name during a broad-sweep intelligence review of individuals with what the agency internally labeled connections to nations of concern. Her connection was this. Her late father, a biology professor who had died in 2016, had traveled to Tehran once in 1994 to attend an academic medical conference. That single trip, over 30 years ago, by a dead man, became the seed of the entire case. Loomis built an affidavit alleging that Barbara maintained undisclosed foreign contacts with Iranian intelligence assets. He cited wire transfers she had sent to elderly family members in Lagos as financial activity consistent with covert channels. He pointed to her professional travel to The Hague for a judicial conference, a trip organized by the U.S. State Department, and described it as indicative of clandestine meetings with foreign operatives. Every claim in the affidavit was either a deliberate distortion or an outright fabrication. No corroborating intelligence existed from the CIA, the NNSA, or the FBI. No other agency had flagged her name. No confidential informant had provided testimony. Loomis submitted the warrant application to Magistrate Judge Howard Pruitt, a 61-year-old jurist with a reputation for moving fast through his docket. Pruitt signed the warrant after a 9-minute review. He asked 0 questions. He requested no supporting documentation beyond the affidavit itself. And with that signature, 12 armed agents were authorized to break down the door of a sitting federal judge and drag her from her bed in front of her children. For 3 hours and 14 minutes, agents moved through every room of Barbara Okuwosa Adeyemi's home, with the efficiency of men who believed they were untouchable. Bodycam footage from multiple agents would later document what they seized. Laptops from the home office, cell phones from the kitchen counter and both children's bedrooms, family photo albums pulled from a living room shelf, Barbara's judicial case files, binders and folders containing active federal proceedings, carried out in open boxes without covers or seals. Her children's tablets, financial records from a filing cabinet in the hallway, her late husband's medical files, still kept in a drawer beside his side of the bed, and a box of personal letters her father had written to her mother from Nigeria over the course of 40 years, the same letters Loomis had described in his affidavit as coded communications. Barbara sat zip-tied in a kitchen chair the entire time, still in pajamas, watching agents dismantle her home around her. She asked 4 times to call her attorney. Each time she was told the request would be processed later. She asked 3 times for her children to be brought to her, denied without explanation. Down the hall, Rosalind sat in her parents' bedroom with an agent by the door, sobbing, asking over and over if her mother was being arrested. No one answered her. In his own room, Nnamdi sat on the floor with his back against the bed, guarded by an armed agent in tactical gear, clutching a stuffed bear his father had given him. He did not speak. He did not move. Loomis personally entered Barbara's home office and began reading through her judicial case files. When a younger agent standing nearby asked quietly whether they should be handling court documents, Loomis did not hesitate. "She's not a judge today. She's a suspect." 3 minutes after the first flashbang shattered Barbara's living room window, Bill Tavares was standing on his porch across the street in a bathrobe and slippers, phone raised, recording. Tavares was 68 years old, a retired firefighter with 30 years of service and the kind of instinct that told him when something was deeply wrong. He had seen the tactical vehicles pull onto the block at 5:44 a.m. He had watched a dozen agents in helmets and body armor pour out and stack up along the front of the house. And when the grenade went off and the door came down, he pressed record. Over the next 2 hours, his phone captured everything visible from the street. Agents moving in and out carrying boxes, evidence bags clearly containing children's electronics, small tablets and laptops sealed in clear plastic. A moment, 53 minutes into the footage, where an agent walking toward a vehicle held up a framed family photograph and said something to a colleague that made both of them laugh. Tavares caught the moment. Rosalind's face appeared briefly in a second-floor window, tears visible even at distance, before an agent pulled the curtain shut from inside. He walked toward the perimeter once and asked an agent what was happening. He was told to return to his residence immediately. He stepped back, but kept recording. He did not go inside. That evening, sitting in his kitchen with the footage still on his phone, Tavares told a reporter something he would repeat in every interview that followed. "I spent 30 years running into burning buildings. I've seen houses raided for drugs. I've seen bad situations. But I have never in my life seen anything like what they did to that woman and those kids. And I knew right then somebody needed to see this." At 9:15 a.m., 3 hours and 28 minutes after the first agent crossed her threshold, Barbara Okuwosa Adeyemi was finally permitted one phone call. She dialed Obiora Nwankwo, her attorney and one of her closest friends, a constitutional law specialist who had known her since their years together at Harvard. Bodycam footage from the agent standing nearest to the kitchen captured the call. Barbara's voice was controlled, measured, almost clinical, the voice of a woman trained to function under pressure. But the camera also captured what her voice did not betray. Tears running down both cheeks, her jaw tight, her zip-tied hands trembling against the kitchen table. "They broke into my house. They terrorized my children. They are calling me an Iranian spy. I need you here now." Nwankwo arrived in 40 minutes. He walked through the damaged front door in a suit, briefcase in hand, and identified himself immediately as counsel for Judge Okuwosa Adeyemi. Loomis, standing in the living room reviewing a stack of seized documents, barely looked up. Nwankwo stepped closer and spoke clearly enough for every body cam in the room to record it. "My client is a sitting United States federal district judge for the District of Columbia. You have seized active judicial case files from her home office. That is an unconstitutional violation of the separation of powers and judicial independence." The room went quiet. Agent Bryce Dillingham, standing near the hallway, looked at Loomis. Two agents near the front door exchanged a glance. Loomis's expression did not change, but his hand stopped moving over the papers in front of him. "We'll verify that," he said. Wonkwa's response was immediate. "You should have verified it before you put a flashbang through her window." Loomis stepped into the backyard and called his section chief, Supervisory Special Agent Donna Kessler. He kept his voice low. Kessler ran the name through the Federal Judiciary Personnel Database. The confirmation came back in under 2 minutes. Barbara Okuosa Adeyemi, confirmed sitting judge, United States District Court for the District of Columbia. Appointed by the President of the United States. Senate confirmed. Active caseload of over 60 pending federal cases. The ambient audio from a body cam still recording in the kitchen picked up Kessler's voice through the phone speaker, tight and clipped. "Craig, what have you done?" Loomis said nothing for several seconds. Then he walked back inside and told his team to begin wrapping up. He did not apologize to Barbara. He did not order her zip ties removed immediately. He did not instruct agents to return the judicial case files. Instead, he stepped outside again, pulled out his personal cell phone, and made a second call off Bodycam. No record exists of who he called or what was said. When he returned to the kitchen, he addressed Nwankwo with the flat tone of a man still trying to control a situation that had already left his hands. "The investigation is ongoing. Seized materials will be reviewed and returned if appropriate." Nwankwo was already standing, his briefcase open, a legal pad filled with notes. He looked directly at Loomis, his voice steady and precise. "You have just raided a federal judge's home on fabricated evidence, seized constitutionally protected judicial files, and terrorized her children. This is not going to be reviewed. This is going to be investigated, but not by you." At approximately 10 a.m., more than 4 hours after the raid began, an agent finally cut the zip ties from Barbara Okuosa Adeyemi's wrists. The plastic had left deep red grooves in her skin. She did not rub them. She stood, walked to the hallway, and asked for her children. Namdi was brought to her first. The 11-year-old crossed the kitchen at a run and wrapped both arms around her waist so tightly she had to brace herself against the counter. He did not let go for nearly 20 minutes. He did not speak. Rosalind came next, led by an agent she refused to look at. She sat down in a kitchen chair, folded her hands in her lap, and stared at the wall. She said nothing. Her eyes were dry and distant in a way that unsettled Nwankwo more than the tears had. The house looked like it had been torn apart by people who did not care what they broke. Furniture was overturned, drawers had been pulled out and emptied onto floors. Closets stood open with clothes dragged from hangers. Her late husband's study, the room she had kept exactly as he left it, had been ransacked. His books pulled from shelves, his desk drawers dumped. In the upstairs hallway, a framed photograph of her parents' wedding lay face down on the carpet. The glass cracked in a long diagonal line. Barbara walked through every room with Nwankwo beside her, documenting the damage with her phone. She did not cry again. Her voice was flat, precise, cataloging each violation like evidence. "They took the kids' laptops. They took my case files. They took the letters my father wrote to my mother." By 11 a.m., Nwankwo was on the phone with the chief judge of the D.C. District Court. By noon, the Judiciary's administrative office had been formally notified. By 2 p.m., a written complaint had been filed with the Department of Justice, Office of the Inspector General. By evening, 3 United States senators had been quietly briefed by senior judicial officials. The machinery of accountability had begun to move. But inside the house, Namdi was still holding on to his mother, and Rosalind had not said a word. On the morning of March 2, 2026, Bill Tavares sent his footage to a reporter at a local television station. He had not slept. By midday, the story was everywhere. Every major outlet ran some version of the same headline, and each one landed harder than the last. Homeland Security raids federal judge's home, calls her Iranian spy. Black federal judge zip-tied in own home during pre-dawn raid. HSI agents seized active judicial case files during raid on judge's home. Legal analysts went on air within hours, calling it one of the most egregious violations of judicial independence in modern American history. Former federal prosecutors described the seizure of active case files as an act that strikes at the foundation of the separation of powers. Civil rights organizations issued formal statements demanding a full federal investigation. The Federal Judges Association, a body that almost never comments publicly on individual cases, released a rare and sharply worded condemnation. Social media erupted. The Bodycam footage had not yet been released, but Tavares's exterior video was viewed over 4 million times by nightfall. One frame in particular spread faster than any other. Agents in tactical gear carrying labeled evidence boxes down the front steps of the house while, in a second-floor window above them, the face of a child was barely visible behind a curtain, mouth open, crying. That image became the defining picture of the case. By late afternoon, HSI leadership moved. Senior Agent Craig Loomis and Supervisory Special Agent Donna Kessler were both placed on administrative leave pending internal review. Magistrate Judge Howard Pruitt, who had signed the warrant after 9 minutes and 0 questions, issued no public comment. But by evening, sources close to the court confirmed he had retained personal legal counsel. The silence from Pruitt's chambers said more than any statement could have. On the afternoon of March 2nd, Obiora Nwankwo filed an emergency motion to unseal and challenge the search warrant affidavit that had authorized the raid on Barbara Okuosa Adeyemi's home. A federal judge in the neighboring District of Maryland granted the motion within hours, citing extraordinary circumstances involving the constitutional integrity of the judiciary. By evening, the affidavit was public, and when legal analysts began reading it on live television, what they found was not an intelligence case. It was a fabrication held together by distortion and audacity. The Iranian connections that Loomis had cited as the foundation of his case amounted to a single trip to Tehran in 1994 by Barbara's late father, a biology professor who had attended an academic medical conference and had been dead for a decade. The covert financial channels were routine wire transfers, fully documented and tax reported, sent to elderly relatives in Lagos. The clandestine meetings at The Hague referred to Barbara's attendance at a judicial conference organized by the United States State Department itself. She had been formally invited by the federal government to attend the very event Loomis described as evidence of espionage. There was no confidential informant named anywhere in the document, no corroborating intelligence from the CIA, the NSA, or the FBI, no interagency coordination of any kind. Loomis had built the entire case from open-source records, deliberate mischaracterizations of lawful activity, and his own unsubstantiated assertions presented as fact. Former federal prosecutors appeared on every major network, calling it the thinnest affidavit they had ever seen approved by a sitting magistrate. Questions mounted quickly about Magistrate Judge Howard Pruitt's 9-minute review, whether he had read the document at all, and whether the rubber stamping of a warrant this baseless represented its own form of institutional failure. By the evening of March 2nd, the legal filings were done, the phone calls to senators had been made, and the news cycle was burning with her name. But inside the house in Silver Spring, none of that reached the 2 children trying to sleep in bedrooms that no longer felt safe. Rosalind had spoken fewer than a dozen words since the morning of the raid. She flinched at sudden sounds, the creak of a door, a car engine outside, the neighbor's dog barking. She asked her mother once, quietly, standing in the hallway before bed, "Are they going to come back?" Barbara told her no, but the question hung in the air because Barbara could not promise that with the certainty her daughter needed. Nnamdi had not slept through the night since March 1st. He had begun wetting the bed again, something he had not done since he was 5 years old. On the night of March 2nd, as Barbara tucked him in, he looked up at her with an expression no 11-year-old should carry and asked, "Did you do something bad, Mama?" Barbara held his face in both hands and told him no. She told him she had done nothing wrong. She told him the people who came to their house had made a mistake. But she could see in his eyes that the answer did not land the way it needed to, because the damage was not about information. It was about what had been taken from him. The belief that his home was a place where nothing could hurt him. After both children were in bed, Barbara closed her bedroom door, sat on the edge of the mattress, and called her sister in Baltimore. Her voice, the same voice that had stayed level through zip ties and interrogation and federal motions, finally broke. "They didn't just raid my house. They stole my children's sense of safety. I don't know how to give it back." A child psychologist who would later evaluate both Rosaline and Namdi would describe their symptoms as consistent with acute trauma disorder. The report would note hypervigilance, sleep disruption, emotional withdrawal, and regressive behavior. It would note that these symptoms had been caused not by an accident or a natural disaster, but by agents of their own government, in their own home, in the dark. As of March 3, 2026, the machinery of accountability is turning, but no one has yet been held to account. Multiple investigations are now open simultaneously, each pulling at a different thread of the same catastrophic failure. The Department of Homeland Security Office of Inspector General has launched a formal probe into Senior Agent Craig Loomis, Agent Bryce Dillingham, Supervisory Special Agent Donna Kessler, and the full approval chain that authorized the warrant. The Department of Justice Inspector General is conducting a separate investigation into whether the raid constituted an obstruction of judicial function, a question with constitutional implications that reach far beyond a single case. The Judicial Conference of the United States, the policymaking body for the entire federal court system, has convened an emergency session focused specifically on the seizure of active case files from a sitting judge's home. In a statement released this morning, the conference called the seizure a direct assault on the independence of the federal judiciary. The FBI has opened a parallel criminal inquiry into whether Loomis fabricated evidence in the affidavit, which, if proven, would constitute a federal crime carrying significant prison time. Congressional leaders from both parties have demanded hearings. Letters have been sent to the DHS Secretary, the Attorney General, and the Director of National Intelligence, requesting full briefings. Loomis, through his attorney, has released a single statement claiming he acted in good faith based on available intelligence. Kessler has not commented publicly. Dillingham has reportedly retained separate counsel and requested to cooperate with investigators. Magistrate Judge Howard Pruitt has been quietly recused from all pending cases on his docket. And the seized judicial files, the active case documents taken from Barbara Okuwosa Adeyemi's home office, have not yet been returned. Among her colleagues on the federal bench, Barbara Okuwosa Adeyemi is described the same way by nearly everyone who knows her work. Principled, thorough, fearless when it matters. Over 4 years on the bench, she built a record that earned respect from prosecutors and defense attorneys alike. But it was her rulings on government surveillance that drew the most attention. She had written multiple opinions pushing back on overreach by federal agencies, including the Department of Homeland Security. She had questioned the scope of warrantless data collection. She had demanded specificity in affidavits where other judges accepted vague language. 2 of her Fourth Amendment opinions had been cited by appellate courts as models of constitutional reasoning. She had, in short, done exactly what a federal judge is supposed to do. She held power accountable. And now, legal commentators across the country are asking the question openly. Was this really an intelligence failure? Or was it retaliation? Was a black woman who dared to check federal authority made into a target by the very apparatus she had held to account? No direct evidence of retaliation has emerged. Not yet. But the investigation is ongoing, and the coincidence has not gone unnoticed by anyone paying attention. Barbara herself has not spoken publicly. She has not appeared on camera. She has not given interviews. Through Obira Nwankwo, she released a single written statement on the evening of March 2nd. It read, "I swore an oath to uphold the Constitution of the United States. On March 1st, agents of the federal government broke into my home and violated that Constitution in front of my children. I intend to ensure that every person responsible is held accountable. Not for my sake, but because if they can do this to a federal judge, they can do it to anyone." This story is not finished. As of March 3, 2026, No one has been charged. No one has been fired. No one has been arrested. The judicial case files seized from Barbara Okuosa Adeyemi's home remain in government custody, active federal proceedings handled by agents who had no legal right to touch them. Barbara's children are still not sleeping through the night. Rosaline still flinches when a door closes too hard. Namdi still crawls into his mother's bed before dawn, afraid of the dark in a way he never was before. Craig Loomis is on paid administrative leave, collecting a federal salary from his home, while the woman whose door he broke down tries to explain to an 11-year-old why the people who are supposed to protect them were the ones who came with guns. The investigations are open. The Inspector General is reviewing. The FBI is examining. Congress is demanding answers. But the process is slow, deliberate, and offers no comfort to a family still living in a house with a front door that no longer locks properly and a living room window still boarded up with plywood where a flashbang grenade came through before sunrise on a Saturday morning. The public is watching. The legal community is watching. Civil rights organizations are watching. And somewhere in a quiet house in Silver Spring, Maryland, a federal judge is sitting on the edge of her daughter's bed, smoothing her hair, telling her it is safe to close her eyes, knowing that she cannot yet prove that is true. This is not a story with a resolution. Not yet. But the cameras were rolling. The Bodycam footage exists. The neighbor's video exists. The affidavit is public. The evidence is preserved. And the people responsible have names, badges, and records that are now under a level of scrutiny they never imagined possible. Because when they planned this raid, when they drafted that warrant, when they threw that grenade and broke down that door, they assumed the woman in pajamas on the hallway floor was no one who mattered. They were wrong. This case was disturbing. But the one on the right ends in a way no one expects.
My name is Vivian Achebe-Laurent. I am a United States District Judge for the Eastern District of Virginia. You need to verify that immediately.
Oh, I know exactly what name is on this address. And I don't care what title you think protects you. We have intelligence tying this house to suspicious foreign activity.
At 6:12 a.m. on Sunday, March 1st, 2026, the smell of pancakes filled a narrow Alexandria townhouse 3 blocks from the Potomac. Judge Vivian Achebe-Laurent stood at the stove in a cotton robe, flipping batter while her 7-year-old son Solomon sat cross-legged on the couch watching cartoons with the volume too loud. Upstairs, her 11-year-old daughter Nadia was already dressed for church, arguing through the bathroom door that Solomon had taken her hairbrush again. It was the kind of morning that didn't make the news. Quiet, ordinary, warm. Vivian was 44 years old, Harvard Law, top of her class. She had spent 6 years as a federal prosecutor at the Department of Justice before being nominated to the U.S. District Court for the Eastern District of Virginia. Senate confirmed 4 years ago with bipartisan support. She carried an active caseload that included 2 national security matters and a high-profile civil rights case that had drawn attention from Washington and beyond. She was disciplined, private, and careful with every word she spoke on and off the bench. That morning, her church dress hung on the back of her bedroom door. Solomon's clip-on tie sat on the kitchen counter next to a sippy cup he swore he didn't use anymore. Nadia's Bible study notebook was open on the dining table, a colored pencil still wedged in the spine. Vivian had no idea that in less than 30 minutes, the front door of her home would be blown off its hinges, that federal agents in tactical gear would pour into her kitchen, that her son would be dragged off that couch and put face down on the floor, that her daughter would be grabbed by the arm at the top of those stairs, and that everything about this morning, every quiet, ordinary detail, would become evidence in one of the most devastating federal civil rights cases in modern American history. 6 weeks earlier, on a Tuesday afternoon in January, FBI counterintelligence analyst Craig Stenner sat at his desk inside the J. Edgar Hoover building in Washington, scrolling through the Bureau's online tip portal. Stenner was 36, competent enough on paper, but known among colleagues as someone who chased volume over accuracy. He flagged more tips than anyone in his unit. Most went nowhere. He didn't seem to mind. At 2:17 p.m., a submission caught his eye. It alleged that a woman living at 814 Braddock Lane in Alexandria, Virginia, had been making wire transfers to financial entities with suspected ties to Iranian intelligence. The tip included a name, Vivienne Achebe Laurent, a partial physical description listed as black female, early 40s, and a claim that she had been photographed at a restaurant in Georgetown with a known Iranian diplomatic attaché. There was no supporting documentation, no account numbers, no surveillance imagery, no name attached to the person submitting the tip. It had come through an anonymous portal entry routed through a burner email. Stenner flagged it and forwarded it to his supervisor, Special Agent in Charge Brent Kirkwood. Kirkwood was 52, a career bureau man with a reputation for aggressive case development and a deep interest in counterintelligence headlines. He read the tip once, asked no follow-up questions, and approved it for preliminary investigation the same afternoon. No one ran Vivienne's name through the federal judiciary employee database. No one checked whether she held a government position. No one cross-referenced her address with any law enforcement or intelligence personnel records. The tip was vague, uncorroborated, and anonymous. It should have been flagged for further vetting at minimum, or dismissed outright. Instead, Kirkwood told his team to move fast. He called it a potential high-value lead, and from that moment on, every decision that followed was built on a foundation that no one in the Bureau had bothered to verify. Over the next 6 weeks, every safeguard that should have caught the mistake failed. Not one of them held. Stenner built the case file the way he built most of his cases: fast, surface level, and with just enough material to look thorough without actually being thorough. He pulled Vivienne's financial records through a parallel channel typically reserved for FISA-adjacent national security requests, a move that bypassed the more rigorous internal review process. What he found should have told him everything he needed to know. Vivienne had made recurring donations to a legal aid nonprofit that served immigrant communities, including clients from the Middle East. The transactions were modest, documented, and tax-deductible. Stenner flagged them as suspect wire transfers to entities with foreign ties. He never contacted the nonprofit, never checked its tax status, never noted that it had been operating legally in Virginia for over a decade. Then came the photograph. During a 2024 legal conference in Washington hosted by the American Bar Association, Vivienne had posed in a group photo with more than a dozen attendees. One of them happened to be a mid-level Iranian diplomatic attaché who had been invited to a panel on international law. Vivienne hadn't spoken to him individually. She didn't know his name. But the photo made it into the file, captioned as evidence of a potential clandestine relationship. A junior analyst in the unit, Priya Venkatesh, 29, raised concerns in a written memo. She pointed out that the financial records didn't support the conclusion being drawn, that the tip was anonymous and uncorroborated, and that no one had verified the subject's employment or government affiliation. Kirkwood read the memo, called her into his office, and told her to stay in her lane. 2 days later, her objections were removed from the case file entirely. Kirkwood told his team this could be a big one, and no one left in the room was willing to tell him he was wrong. The warrant application landed on the desk of a federal magistrate judge in the Eastern District of Virginia on February 26, 2026. The affidavit was 12 pages long and built almost entirely on 3 pillars: the anonymous tip, the mischaracterized financial records, and the conference photograph. Each piece of evidence had been framed to suggest something it did not actually prove. The charitable donations became suspect international transfers. The group photo became a documented meeting with a foreign intelligence-linked operative. The anonymous tip became a credible source with knowledge of the subject's activities. What the affidavit did not include was any mention of Vivienne Achebe Laurent's occupation. It did not state that she was a sitting United States District Judge. It did not note her prior service as a Department of Justice prosecutor. It did not reference her Senate confirmation, her security clearances, or her active national security caseload. The magistrate judge reviewed the affidavit, asked no clarifying questions, and signed the warrant that same afternoon. Kirkwood moved immediately. He assembled a full tactical entry team of 14 agents, body armor, sidearms drawn, flashbang grenades authorized. The raid was scheduled for 6:45 a.m. on Sunday, March 1st, a time specifically chosen because the subject would be home and, in Kirkwood's words, less likely to have outside support present. No one on the team suggested a less invasive approach. No one proposed a simple knock on the door. No one recommended calling her attorney or serving the warrant through the court. 14 agents, full tactical gear, drawn weapons, a battering ram, and a federal judge making pancakes for her children on the other side of the door. The operation was approved without a single voice asking whether any of it was proportionate. At 6:44 a.m., 1 minute ahead of schedule, the battering ram hit the front door of 814 Braddock Lane. The lock shattered on the first strike. The door frame splintered inward, sending wood and metal across the entryway floor. 2 flashbang grenades followed, one into the living room, one toward the kitchen. The concussive blasts shook the walls. Solomon, who had been lying on the couch watching cartoons with a blanket pulled to his chin, screamed. An agent in full tactical gear reached him in 3 steps, pulled him off the cushions by his arm, and forced him face down onto the hardwood floor. He was 7 years old. In the kitchen, Vivienne spun toward the sound just as 2 agents came through the doorway. One grabbed her by the shoulder and drove her sideways into the counter. Her face struck the granite edge. The impact split the skin above her left eye. Blood ran down her cheek before she hit the floor. She was forced onto her stomach, arms wrenched behind her back, wrists locked into handcuffs. She could hear Solomon crying from the living room. She could hear boots on the stairs. "I am a federal judge," she said. Her voice was loud and clear despite the blood and the pressure on her spine. The agent kneeling on her back didn't pause. "Sure you are," he said. Upstairs, Nadia heard the explosions and the screaming and came running down the staircase in her church dress, shoes untied, eyes wide. An agent intercepted her halfway down, grabbed her by the upper arm, and brought her to the floor beside her brother. She was 11. She landed on her knees and then her chest, her face pressed to the same hardwood where Solomon lay sobbing. Both children were now on the ground, surrounded by armed men in black helmets, in their own home, on a Sunday morning. Vivienne lay on the kitchen tile with her cheek against the cold floor, blood pooling beneath the cut above her eye, her wrists locked behind her back at an angle that sent pain through both shoulders. Her breathing was controlled. Her voice, when she spoke again, was steady and precise. "My name is Vivienne Achebe Laurent. I am a United States District Judge for the Eastern District of Virginia. My judicial credentials and identification are in my study. Second door on the left, top drawer. You are making a catastrophic mistake." The lead entry agent, Supervisory Special Agent Russ Pennington, 45, stood over her. For the first time since the breach, he did not move immediately. Something in her tone, in the specificity of her words, in the calm that no ordinary person under duress could manufacture, made him pause. He keyed his radio. "Command, the subject is claiming to be a federal judge, requesting guidance." The response came from Kirkwood, sitting in a black SUV parked 2 houses down, monitoring the operation on a tablet. "Continue the search. She can sort it out downtown." Pennington hesitated for half a second longer, then gave the order. Agents moved through every room. Books were pulled off shelves and thrown to the floor. Drawers were dumped. Closets were emptied. They seized both of Vivienne's laptops, her personal phone, an external hard drive containing case research, her children's school tablets, and 3 family photo albums. In the living room, Solomon had stopped crying and gone silent, his small body trembling, a dark stain spreading across the front of his pajama pants. He had wet himself. Beside him, Nadia lay with her eyes open and her chest heaving in short, shallow gasps, unable to slow her breathing, unable to speak. A federal judge's children, face down on their own floor, surrounded by agents who still had not verified who their mother was. And in the SUV outside, Kirkwood checked his watch and typed a message to headquarters. "Raid executed. Subject secured. Proceeding with evidence collection." The noise carried. In a neighborhood like this one, where the houses sat close and the streets stayed quiet on Sunday mornings, the sound of a door being broken open and flashbang grenades detonating was impossible to miss. Frank Oberlin was the first one outside. He was 68, retired Army colonel, lived in the townhouse directly next door, and had known Vivienne for 3 years. He had watched her carry groceries inside on weeknights, had waved to her children when they played on the front steps, had attended the same neighborhood association meetings where she sat quietly in the back row, always polite, always composed. When he stepped onto his porch and saw the black SUVs, the tactical gear, and the agents moving in and out of Vivian's front door, he walked straight to the perimeter tape. "That's a federal judge's home," he told the agent guarding the line. "Her name is Vivian Achebe Laurent. She sits on the Eastern District bench." The agent didn't blink. "Sir, step back or you'll be detained." Oberlin didn't move. "You're making a mistake. I'm telling you who lives in that house. Step back. Now." Oberlin pulled out his phone and began recording. Across the street, Terrence and Simone Osei had come to their front window when the first blast shook the block. Terrence grabbed his phone and started filming from the doorway. The footage was shaky, but clear. Agents in full tactical gear, a broken front door, and then, at 7:03 a.m., the image that would later be seen by millions. Vivian Achebe Laurent, in a cotton robe and church slippers, blood visible on the left side of her face, hands cuffed behind her back, being walked down her own front steps by two agents while a neighbor's child watched from a second-floor window across the street. Within minutes, the footage was in a neighborhood group chat. Within an hour, a local journalist had it in her inbox. Within 2 hours, it had already been shared more times than anyone in that neighborhood could have predicted, and not a single agent on the scene had yet confirmed who they had just raided. At the FBI's Washington field office, Vivian was placed in an interrogation room on the 3rd floor. The handcuffs stayed on. The cut above her eye had not been treated. Blood had dried in a thin line down her left cheek and along her jaw. She sat upright in a metal chair, still wearing her robe and slippers, and said nothing. She did not ask for water. She did not ask where her children were. She asked for one thing. "I want my attorney. I will not answer questions without counsel present. I am a sitting United States District Judge. You can verify this in less than 60 seconds. The two agents in the room exchanged a glance. One left. The other stayed by the door, arms folded, silent. Vivienne sat still. For nearly 2 hours, no one verified her identity. No one ran her name through the federal judiciary database. No one contacted the Eastern District Clerk's office, which operated a 24-hour duty line specifically for emergencies involving judicial personnel. At 9:14 a.m., more than 2 hours after the raid, a junior agent who had not been part of the entry team typed Vivienne's full name into the federal court's personnel system. The result appeared in under 4 seconds. Achebe Laurent, Vivienne R. Title: United States District Judge. Court: Eastern District of Virginia. Status: active. Appointed by the President. Confirmed by the Senate. The agent stared at the screen, pushed back from his desk, and walked quickly down the hall. He found Kirkwood in a briefing room reviewing evidence logs. "Sir, the subject is a federal judge." Kirkwood looked up. "What?" "She's a sitting U.S. District Judge. Eastern District of Virginia. Senate confirmed. Active bench." The room went quiet. Every agent in it understood in the same instant what had just happened and what was about to come. Kirkwood set down the file he was holding. His face lost its color. Down the hall, in the interrogation room, Vivienne sat exactly as she had for the last 2 hours. Bleeding. Calm. Waiting. And somewhere on the 3rd floor, someone finally thought to ask the question that should have been asked 6 weeks ago. Did anyone check who she actually is? While Vivienne sat in that interrogation room for 2 hours, waiting for someone to confirm what she had told them from the moment they broke down her door, her children were in a separate room on a different floor of the same building. Solomon and Nadia had been transported in the back of an unmarked federal vehicle. No car seats, no seatbelts fitted for a child Solomon's size. No explanation of where they were going or why. Solomon had not spoken since the agents put him on the floor of his own living room. He sat in a plastic chair with his knees pulled to his chest, still in the pajamas he had wet during the raid, the fabric now cold against his skin. No one had offered to change him. No one had offered him clothes or a blanket or food. He was 7. Nadia sat beside him, rigid, staring at the wall across the room. She had stopped hyperventilating in the vehicle, but had not spoken a full sentence since being pulled to the ground on the staircase. When a victim's advocate was finally brought in, more than 90 minutes after the children arrived, she found them sitting in silence in a room with no windows, no toys, no crayons, nothing that acknowledged they were children. The advocate, a woman in her 50s who had worked with the Bureau for over a decade, later told investigators it was one of the worst things she had seen in her career. A child psychologist brought in that afternoon conducted preliminary evaluations on both children. Solomon exhibited signs of acute stress response, including trembling, selective mutism, and a flinch reaction triggered by any sudden movement or loud sound. Nadia presented with emotional shutdown, flat affect, and what the psychologist described as hypervigilant stillness, a trauma response more commonly associated with children in war zones. Vivian was not allowed to see her children until 9:47 a.m., nearly 3 full hours after they had been separated. When she finally entered the room, still in handcuffs that had only just been removed, Solomon looked up at her and said one word: "Mama." It was the first thing he had said in over 3 hours. By 10 a.m. on March 1st, the machinery of institutional panic had begun to move. The first call went from the FBI's Washington field office to the chief judge of the Eastern District of Virginia. The conversation lasted less than 2 minutes. The chief judge's response, according to sources briefed on the call, was a single question, repeated 3 times. "You did what?" By 10:15, the administrative office of the U.S. courts had been notified. By 10:30, 2 United States senators with oversight of the Judiciary Committee had received calls from their staff flagging an incident involving a sitting federal judge. By 10:45, the FBI Director's Office was alerted through an internal channels memo marked urgent, a classification rarely used outside of active threat scenarios. Kirkwood was pulled from the case before noon. He was told to return to the field office and not to contact any member of the investigative team. Stenner, the analyst who had flagged the original tip and built the case file without ever verifying the subject's identity, was placed on administrative leave effective immediately. His access to classified systems was suspended. Supervisory Special Agent Russ Pennington, who had led the tactical entry, was reassigned to administrative duties pending review. The DOJ Office of Professional Responsibility opened an emergency inquiry before the end of the day. Behind closed doors at the Hoover Building, the damage assessment was already underway. A deputy director convened an emergency meeting with senior leadership from counterintelligence, legal counsel, and the inspection division. The question he asked the room, according to 2 officials present, was direct. How did we raid the home of a sitting federal judge, put her face down on her kitchen floor, hold her children in a windowless room for 3 hours, and not one person in this building knew who she was? No one answered immediately. The silence in that room carried the weight of what everyone already understood. This had not been a failure of technology or access. The databases existed. The information was there. No one had looked because no one had thought to look. A black woman with an African surname living in a nice neighborhood had matched someone's idea of a threat, and from that point forward, every system designed to prevent exactly this kind of catastrophe had been bypassed, ignored, or overridden. And now the entire Bureau was going to answer for it. The neighbor footage reached social media before the FBI had even confirmed Vivian's identity. Terrence Osei's video was 43 seconds long. Shaky, slightly overexposed in the early morning light, but unmistakable. A black woman in a cotton robe and church slippers, blood on her face, hands cuffed behind her back, being walked down the steps of her own home by 2 agents in tactical gear. Behind her, through the broken front door, the audio captured a child screaming. The video hit a neighborhood group chat at 7:11 a.m. By 7:40, a local journalist had it. By 9 o'clock, a Washington reporter confirmed through court records that the woman was a sitting United States District Judge. The story detonated. Every major outlet ran some version of the same headline. FBI raids home of black federal judge. The footage played on loop across cable news and social media. Legal analysts called it unprecedented. The National Bar Association issued a statement calling the raid one of the most egregious violations of judicial independence and civil rights in modern American history. The NAACP demanded a full independent investigation. By evening, 14 sitting federal judges had signed a rare joint statement expressing profound concern over the treatment of their colleague. 2 members of Congress called for emergency oversight hearings. A constitutional law professor at Georgetown told a reporter she had never seen anything like it in 30 years of studying federal law enforcement. And in a windowless room at the Washington field office, the 2 children at the center of it all still had not been given a change of clothes. In the days that followed, the institutional rot beneath the raid began to surface. Investigative journalists filed records requests on Kirkwood's counterintelligence unit. What emerged was a pattern stretching back nearly a decade. Of 41 investigations opened by his team over 8 years, 29 had targeted individuals who were Black, Middle Eastern, or South Asian. More than half were initiated on anonymous or thinly sourced tips. Fewer than a third produced anything actionable. None led to a prosecution. Kirkwood's unit had operated under national security classification that shielded it from routine oversight. Internal review mechanisms deferred to his judgment. The result was a team with minimal accountability and a supervisor who treated aggression as ambition. Priya Venkatesh, the junior analyst who had flagged concerns 6 weeks before the raid, cooperated with the DOJ Office of Professional Responsibility. Her written memo questioning the case's evidentiary basis had been removed from the file before the warrant application reached the magistrate. Kirkwood had told her to stay in her lane. She had kept a personal copy. She turned it over to investigators on March 2nd. Separately, digital forensics teams began tracing the anonymous tip. The submission had come through a burner email created the same day, routed through a VPN. But metadata recovered from the portal's backend pointed to someone familiar with federal court procedures. Investigators began quietly exploring a possibility that would transform the case entirely: that the tip had been fabricated by someone connected to one of Vivian's active rulings. If confirmed, it would mean the FBI hadn't just failed to vet the evidence, it had been weaponized. As of March 2nd, 2026, Vivienne Achebe-Laurent has not spoken publicly. Not a single word to the press, no interviews, no statements on camera. Her attorney, former federal prosecutor Camille St. Pierre, issued a brief written statement on her behalf that afternoon. It confirmed that a federal civil rights lawsuit was being prepared. It requested the immediate preservation of all body camera footage, tactical communications, surveillance recordings, internal emails, and case files related to the investigation. It stated that both children were being evaluated by a trauma specialist and that the family was requesting privacy while they began to process what had happened less than 24 hours earlier. The statement was 4 paragraphs long. It said everything it needed to say, and nothing more. Legal observers noted that Vivian's silence was not absence, it was strategy. She was a sitting federal judge who understood that every word she spoke publicly would be scrutinized, dissected, and potentially weaponized to paint her as emotional, politically motivated, or unfit for the bench. Her restraint was not weakness. It was the discipline of a woman who had spent her career inside the system and understood exactly how to dismantle its failures from within. Behind the scenes, her legal team had already contacted the DOJ Inspector General, the Judicial Council, and 2 congressional offices with jurisdiction over both the judiciary and federal law enforcement. The machinery was beginning to move, but Vivian had not yet shown her hand, and anyone who knew her understood that when she did, it would not be emotional. It would be precise. As of this moment, nothing is resolved. Kirkwood has been suspended from duty pending investigation. Stenner has retained a private attorney. Supervisory Special Agent Pennington has been reassigned. The magistrate judge who signed the warrant is under review by the Judicial Council for failure to scrutinize the affidavit. The FBI has issued a single, carefully worded statement acknowledging what it called procedural shortcomings in the investigation. It has not apologized. Congress has called for oversight hearings. 2 Senate committees have requested full briefings from the Bureau's director. Vivian's lawsuit, filed in the District of Columbia, names the FBI, Kirkwood, Stenner, Pennington, and 12 unnamed agents. It alleges violations of the Fourth Amendment, racial profiling, excessive force, false imprisonment, and intentional infliction of emotional distress. Nadia and Solomon have been added as plaintiffs. Their claims include trauma, unlawful detention of minors, and denial of basic care while in federal custody. No settlement has been offered. No disciplinary action beyond suspension has been finalized. No criminal charges have been filed against any agent involved. The investigation into the origin of the anonymous tip is ongoing, with digital forensics still tracing the submission through layered VPN routing. If the tip is confirmed to have come from a litigant connected to one of Vivian's cases, the scope of the scandal will expand from negligence into something far more deliberate. But as of today, none of that has been confirmed. None of it has been denied. The front door of 814 Braddock Lane is still broken. The blood has been cleaned from the kitchen counter. Solomon still flinches at loud sounds. Nadia still has not spoken a full sentence to anyone outside her family. And the woman who sat bleeding on her own kitchen floor in handcuffs is still on the bench, still hearing cases, still waiting for the system she serves to answer for what it did. This case was brutal, but the case on the right spirals completely